Good evening. I'm Jim Zirin. Welcome back to Conversations in the Digital Age. Tonight we're going to do something new and different because instead of asking the questions, I'm going to furnish the answers. With us is my good friend Bill Vanden, who is going to interview me about my new book. The book is entitled The Mother Court, Tales of Cases That Mattered in America's Greatest Trial Court, which is the Southern District of New York. Bill, thank you so much for doing this.
Jim, to reverse roles is a great pleasure. You're a wonderful interviewer, and I hope I can elicit from you the depth of this book so that your audience will understand it. Let me just begin by showing the book. There it is, The Mother Court. And Jim Zirin has written this, and by chance, we've gotten a wonderful review in this week from the London Times, the front page of the London Times. So it's, if I may just quote a bit from it, the Mother Court, because it's objective evidence and I don't have to say it's my own opinion, which is equal to this one. The Mother Court, his affectionate, rollicking story of the U.S. District Court for the Southern District of New York, not only tells a very good tale, it covers a range of subjects as topical in Europe as in the United States. The law's response to the threat of subversion, to the mob, to corruption and officialdom and auditing, to sex and obscenity, and to freedom of the press. Now, that's a range of subjects that will engage any audience for a very long time.
Well, I certainly hope so.
Now, I think your audience knows you, but I just want to say a word about you and how you wrote this book. Jim is one of the stellar lawyers of New York City. He is one in a special category of being a litigator. Litigators are very special people. They see the world somewhat differently. They have a very choice way of approaching problems. Generally speaking, as Jim is, you're very articulate. And it's wonderful that you took the time to write this book because we live in a fast-changing world at every level. And one of those levels, and I hope we can bring that out here today, is the changes in the law and how it's practiced. But you call it the Mother Court. So let's start with the Mother Court. What is the Mother Court?
Well, it's called the Mother Court, Bill, because it is the oldest federal court in the country. It was organized in 1789. It is 2 weeks older than the United States Supreme Court. Now, it's also called the Mother Court because lawyers recognize its eminence as a trial court. It's where the iconic judges tried cases. It's where the legendary lawyers like you walk the halls. It's where the fabulously interesting and important cases were tried, particularly in the mid-20th century. Cases involving Russian spies, cases involving mobsters, cases involving, as you point out, the whole range of issues, freedom of the press, you name it, and it was there. And so the Mother Court was always cutting edge, and it continues to be cutting edge.
I mean, one of the things that's happened now, of course, are these cases related to 9/11, for example, or to terrorism. And one of the points you make in the book, I think you believe deeply, is that the Mother Court, the Southern District of New York, is the appropriate site for many of the trials that should be taking place there rather than under military jurisdiction.
Well, we've just had two successful terrorism prosecutions, one involving bin Laden's son-in-law and another involving a propagandist for al-Qaeda who whipped up crowds in London against the West and against the United States. I think it's wrong to try people like Khalil Sheikh Mohammed, who was really the brains behind the 9/11 operation, in Guantanamo before a military tribunal where he will not get all the procedural safeguards that exist in a civilian court, where if he's convicted, as one would expect he would be, since he confessed to the crimes, the horrible crimes, it'll be a subject of debate around the world as to whether international norms were complied with. Here we have 225 years of jurisprudence. Mother Court is celebrating its 225th anniversary this year. Mm-hmm. And that is something that's solid, it's durable, and something on which the whole world can rely, whether there's a conviction or an acquittal, that appropriate standards were complied with.
And especially since they've been successful in several of these terrorist trials, we can see that the court can handle it. probably much better than any other tribunal in America. What was your introduction to the Mother Court?
Well, actually, I'll go into that in a moment. Actually, we had terrorism trials in the Southern District long before 9/11, and we had Mary Jo White brought a number of successful prosecutions also before 9/11. So there's a great deal of experience in handling this type of case. Now, my introduction, funny you should ask, it started when I was in college. It was on vacations. I would go to the courthouse and listen to criminal trials. And I would wander around.
You had already decided you were going to be a lawyer.
Wasn't sure. I thought perhaps I'd be a journalist, a writer. So I've always had that tension that I didn't, and the feeling perhaps it was the road not taken to write. But I became a lawyer, and that evolved over some time. But I remember in 1961 popping into a courtroom presided over by Judge Weinfeld. It was an official corruption case, which was called United States v. Kahaner. It involved Kahaner, who was the U.S. attorney in Brooklyn, and there was conspiracy between Kahaner and Judge Keogh, who was a state court judge in Brooklyn, and a racketeer named Tony Dux Corallo to fix a bankruptcy case, a criminal bankruptcy case in the Eastern District of New York, in Brooklyn. And I remember listening to the summations, particularly. Well, first I remember Judge Weinfeld, who ruled the courtroom with an iron hand. He had deep-set eyes and a Lincoln-esque kind of face. And trial lawyers said, when you tried a case before Judge Weinfeld, you felt you were before the bar of justice. And
you were.
And you were. And there was no nonsense in the courtroom. But Henry Singer, who was a very histrionic kind of lawyer, summed up for Judge Keogh. And as he came to the end of his summation, the bells began to peal in a church adjacent to the courthouse. It was St. Andrew's Church. And there was an inscription on the facade of the church in Latin: "Happy are they who walk in the law of in the law of the Lord. Happy are they who walk in the law of the Lord." And as the bells began to peal, it was so dramatic as a backdrop to the end of his summation. And then, of course, he had to say something. He said, "Listen to them, ladies and gentlemen of the jury. Listen to them. The bells are pealing at innocent Judge Keogh, innocent." Well, 48 hours later, they came back and convicted. So it impressed upon me that guilt or innocence depended on the evidence in the Mother Court and not what any lawyer said. So that was the start of it.
You were sitting there as a spectator.
As a spectator. I never dreamed that 7 years later I'd be appointed an assistant United States attorney by Robert M. Morgenthau, the legendary prosecutor.
Well, let's get to that, because Robert M. Morgenthau speaks so much in our city, in our state, in our country, to the meaning of justice and the enforcement of the law. And he was U.S. attorney at the time.
He was U.S. attorney, and it's interesting, he lived at that time on Independence Avenue in the Bronx.
Right.
And independence was kind of the hallmark of his administration, because he believed that the U.S. attorney for the Southern District of New York should be independent of the Justice Department in Washington. And there were a number of examples of how he asserted that independence. But he ran his own office, and while we reported to the Justice Department administratively, he wouldn't even allow the Attorney General to tell him what ought to be done in a criminal prosecution.
I was in the Justice Department in those days when Robert Kennedy was Attorney General, and I know that among the U.S. attorneys, Robert Kennedy respected Bob Morgenthau more than anyone. Urged him even to run for governor of the state of New York. And then so you entered the U.S. Attorney's Office what year?
1967. I was there for 3 years, and I tried 36 cases in 3 years to a jury, 36 criminal cases. And the first case I tried was before none other than Judge Weinfeld. And let me tell you, that was a baptism in fire. And at the end of the trial, my shirt was just wringing wet. And he really put me through my paces, but I learned an awful lot, and I respected and admired him so very much.
You know, one of the reasons people should read this book is because you do You're a teacher, you're a professor, you're telling how the system works. It was fascinating, the chapter, for example, on picking a jury. Would you relate that experience a little bit, how you saw it?
It's in England where the whole thing started, and England has largely abolished the jury system, but in England, the idea was that you would have people drawn from the community who would know the litigants, who would know the defendant, and that would bring something to bear on the decision and the disposition. So they would say, oh, I know John, he would never steal a horse. Or I know John, that's all he does is steal horses. Now jurors are not allowed to know anything. So if you have a terrorism trial, they'll say, have you ever heard of Osama bin Laden? And if you say yes, you're off the jury. If you say no, well then I don't know what sort of people you get on juries who have just not been in touch with the issues of the day. Although, if you did say, I've heard of Osama bin Laden, they'd say, well, would you be influenced by anything you've read or heard about him, and could you give him a fair trial? They say yes, they have a chance to be on the jury.
Was your experience with the jury system one that validates the idea of a jury?
Yes, I think I have a great respect for jury verdicts. And jurors bring to the courtroom, of course, their biases, which they try to conceal, but also their common sense and their ability to reason and to accept the judge's instructions. Yeah. And you get a disposition, which, of course, could be appealed, but in large measure stands and is respected. Litigators
stand alone in the context of cross-examination. And you can almost see the gleam in the eyes of a great litigator as he approaches the possibility of cross-examining a witness and scoring that one point that's decisive in a case. Can you remember some experience in terms of cross-examination that you can recount?
Well, I have in the book some
wonderful examples.
Some great examples of cross-examination. I remember one which involved an investigator for the Securities and Exchange Commission, who was an accountant, who was helping his mistress to prepare fraudulent financial statements. And it was the defense of seduction. He claimed that she had seduced him. And that all this had happened against his will, and he was just helping her because he was a prisoner of sex, as Norman Mailer would say. So he testified that this was the case, and his wife is in the courtroom, and so I cross-examined him. I said, well, before you met Mrs. Kendall, you knew how to court a woman? Oh, yes. And you knew how to hold her hand? Yes. And you knew how to tell her she was beautiful? Yes. And I said, and then you met Mrs. Kendall. I said, did you hold her hand? Yes. And did you tell her she was beautiful? Yes. Did you tell her you liked her hair? Yes. And did you tell her you loved her? Yes, I did. And I said, and that's seduction, Mr. Friedland? That's seduction? And the wife began to sob. Oh. And there were repeated objections from the defense lawyer, and Judge Palmieri, who presided, said, well, he's just exploring the defense of seduction. But cross-examination is the most efficient tool that anyone has devised for getting at the truth.
Well, you've got to be terribly careful that you don't ask too many questions, or that you ask a question to which you don't know the answer, and it comes back and knocks you down.
Because it could blow up in your face. And,
yeah.
The classic example, which I recite in the book, which was when Arthur Lyman, a great lawyer, examined Oliver North before the Senate committee that was probing the Iran-Contra affair. And he asked North, he said, when this whole thing unraveled and the Iran-Contra scheme had come out publicly, he said, was that the worst day of your life, Colonel North? Now, what kind of answer did he expect to get from a hostile and clever witness? And of course, North said, no, Mr. Lyman, that wasn't the worst day of my life. The worst day of my life was when I was in a foxhole in Vietnam and a grenade came and was lying at my feet, and my best friend threw himself on the grenade and saved my life. That, Mr. Lyman, was the worst day of my life. Well, You see, you
Devastating.
never ask
Devastating.
an open-ended question where you don't know the answer of a hostile witness.
The courts have been called upon to handle many of the major subjects in American culture as you go along, in American politics. Well, probably two cases that really changed America in how it looked at communism and how it looked at its own security. They were 60 years ago, but they're still very important cases, and you do such a wonderful job of describing the Alger Hiss case for one, and the Rosenberg case for the other. Could you comment on those cases?
Well, of course, this was a period of great hysteria. It was known as the Red Scare.
It was the McCarthy era.
And it was the McCarthy era. In fact, McCarthy really got started shortly after the verdict in the Hiss case,
right,
and started
right.
rolling. And it was a period of political demagoguery. It was a period of great fear that the communists, and particularly the Russians, were building a fifth column within the United States, and that it was America had become kind of a hotbed infested with spies in every place, in Hollywood and in the State Department particularly, and in McCarthy went so far as to claim they were in the Army.
Yeah.
Now, the two cases that I treat, because I think they're kind of a metaphor for the evolution of American society away from the concept of the fifth column and the spies in our midst, and kind of aired out the ability of people to dissent and express unpopular ideological views without fear of persecution or of criminal sanctions. So you have the Hiss case, and I think history has shown that Hiss was guilty, and the evidence against him was quite overwhelming, I thought.
But at the time, it divided America like nothing else.
Absolutely divided America, because Hiss, of course, had been a law clerk to Oliver Wendell Holmes. He was the president of the Carnegie Foundation.
Recommended by John Foster Dulles.
Recommended by John Foster Dulles. He had character witnesses such as Felix Frankfurter, who testified at the first trial. And his reputation was impeccable.
Yeah.
And then there's, of course, the famous summation given by later Judge Thomas Murphy, who was Hiss's prosecutor, where he said to the jury, what is all this character evidence? Couldn't Benedict Arnold have called George Washington? And he said, what kind of reputation does a good spy have? The fox barks not when he hunts the lamb. And it was, and the jury convicted. It was a marvelous trial.
And two trials.
Two trials. First trial was a hung jury.
Yeah.
And the transcript of the second trial was required reading for every U.S. attorney. It was in the library there, and it was so well thumbed.
That was Judge Murphy's, where he was the prosecutor.
He was the prosecutor. He later became police commissioner of the city of New York, and then
one of your favorites.
One of my absolute favorites, because he had a marvelous sense of humor. The other was Judge Kaufman's sentence in the Rosenberg case, of which I'm highly critical. I think it was an illegal sentence. I think it was ill-advised. There was no basis for it, and it was disproportionate to sentences given to other spies.
Yeah.
I think the Rosenbergs were undoubtedly spies for the Russians. I think the atomic secrets...
There's some question whether she was.
Some question as to whether she was. But she may have been aware. I think she was undoubtedly aware of what her husband was doing.
Yeah.
But it certainly didn't warrant the death penalty. And I think when you look at other spies, such as Klaus Fuchs, who really was an atomic spy, who got 30 years in jail, the sentence seemed to be horrific. And Justice Frankfurter, was always very critical of Kaufman for the sentence in that case, and he kind of...
It was a burden Judge Kaufman carried for the rest of his life.
Absolutely. First place, he lived in an apartment building on Park Avenue, where the doormen were outfitted in police-like uniforms, which was supposed to scare potential assassins away from Judge Kaufman. The result was he couldn't have gone to the office every day without thinking of the Rosenbergs. The second thing is that he tried for the rest of his life to live down his reputation for having sentenced the Rosenbergs to death. And so he when he got on the Court of Appeals, he began to decide every case that came his way in favor of the press, every First Amendment case. So he became a champion, or an alleged champion, for First Amendment rights. Well, when he died, the headline in the New York Times was, Judge Irving Kaufman dies, judge who sentenced the Rosenbergs, and then below it said, champion of press freedom.
But the execution of the Rosenbergs was shortly after Eisenhower became president. It was another one of those events that just divided the country. And Roy Cohn was a part of all of those years. You've got a very interesting chapter on Roy Cohn in this. How is it that possible that he could have escaped conviction 4 different times?
Well, he was the Teflon defendant, and he was very clever and very shrewd, and he was very hard to catch. In the key trial that occurred was a conspiracy to bribe a city appraiser so that they could get a favorable appraisal in a condemnation proceeding. And the bribe was supposedly paid in the courthouse in the hall beside the courthouse of the mother court, where Cohn was standing trial on some other charge. And so it came down to the end of the trial, and Cohn's lawyer, who'd cross-examined all the witnesses, apparently had a heart attack, and he was rushed to the hospital. And Judge Wyatt said, well, what do we do now? And Cohn said, well, I'll sum up on my own behalf. Cohn had not taken the stand. And so they allowed Cohn to sum up in his own behalf. And he was able to get his personality across to the jury, make all sorts of statements that were uncross-examined, and he was acquitted. The lawyer was back trying cases 3 days later.
But yet in that period, and it's hard to recreate it, the fervor against communism and the Smith Act cases and all the cases, all of which went through the Southern District. There was one case that you talk about particularly with Judge Murray Gerfine. You know, great judges, and all of us, all names are lost in the mists of time. And Murray Gerfine was one of those who people probably wouldn't remember today. But he played an extraordinary role at a time of great challenge to justice. You want to talk a little bit about the Pentagon Papers?
Well, of course, the Pentagon Papers were a study that was done in the Johnson administration of the Vietnam War, and it was a top secret report that was produced by a group of people, notably Les Gelb, who was on the staff of the Defense Department, and Richard Holbrooke. And much of it consisted of newspaper clippings or sections from books and journals about the Vietnam War, but it was about its history, and it was critical of a number of the people in the Kennedy and Johnson administrations who had been involved in the decisions to go to war and what was done. Daniel Ellsberg, who was part of the staff there, had access to the Pentagon Papers, and he disclosed them to a reporter for the New York Times, also to the Washington Post. And a decision had to be made as to whether the New York Times would publish this. This would not happen today because of the internet, because the government wouldn't have time to bring on a suit for an injunction. But then John Mitchell, who was the Attorney General, brought a suit for an injunction against the New York Times so that they would not, and the Washington Post, so they wouldn't publish the Pentagon Papers. And the judge Judge Gesell in Washington, and eventually Judge Gerfine in New York, denied the injunction and said it was a prior restraint on speech. And even though the documents were stolen, the publication of the documents could not be enjoined because of the First Amendment.
And our good friend Jim Goodale played a role in that.
Tremendous role. He was the general counsel for the New York Times, and he urged the New York Times to publish the papers, despite a letter from the Attorney General saying that it would violate national security.
Was in the days when judges prized their independence. Murray Gerfine, for example, was a Republican.
Yes.
He was very close to Tom Dewey. He had been appointed by, I guess Eisenhower had appointed him. But in any event, Nixon had appointed him, actually.
Nixon had appointed him, and actually Nixon, after the decision, elevated him to the Court of Appeals.
Which is a rather good thing, nice thing to say about Nixon.
Nice thing to say. This will kill him with kindness.
But it was a very important decision, and for the freedom of the press, it was just a landmark decision, as so many cases before the Southern District there. You know, as you read the book, you could see why a Hollywood producer would want to buy it. Because there's so many stories in here that really are movies in and of themselves. For example...
Well, from your mouth to God's ears. I'd love to make a movie.
For example, the United States fighting the mob and the Appalachian case, et cetera. Could you talk a minute about...
Well, I think we have just about a minute, but what happened there was 100 mobsters descended upon a farmhouse in upstate New York on the Susquehanna River. And it was raided by the police. And the mobsters ran out into the woods, and the woods were strewn with $100 bills. And the government never found out what the purpose was of the meeting. But they were all they rounded up about 20 of them, and they all told the same story. They said they were visiting the owner of the house, a Mr. Barbera, who was a mobster, who was ailing. And they wanted to commiserate with him. And then almost everyone told that story except for one mobster who said he went there to deliver fish. Well, they were all indicted for conspiracy, and Judge Kaufman conducted a trial. They were convicted. It went up on appeal, and the conspiracy count was thrown out because there was insufficient evidence that they'd all agreed to tell the same story. So that was it in a nutshell. I'm afraid we've run out of time, but thank you so much for doing this, Bill.
It's a wonderful book, and I hope a lot of people read it, and they'll get a great deal of enjoyment and education if they do.
Oh, well, thank you. I hope they do. For the Digital Age, for Conversations of the Digital Age, I'm Jim Zirin. Good night, and all the best.